Hello and welcome, I'm Olas Gerjuk and you're watching Head to Head with UATV. Ukraine's parliament has adopted a law that would protect and reward corruption whistleblowers. What does the law mean and how can it protect and encourage the corruption informing? To talk more about this, we welcome to the studio today Maksym Kostetskyi, lawyer and legal expert. Hello and thank you for joining us today.
Hello, pleasure to be here.
Pleasure to have you here once again. So let's start with describing the common reality in Ukraine. Could you please explain the audience what is the problem with protecting whistleblowers right now in Ukraine? What threats do they face?
The term whistleblower itself has been introduced to Ukrainian legislation in 2014 since the adoption of the law of Ukraine on corruption prevention. But unfortunately, except for the fact that this term has been introduced into the legislation, there have been no additional instruments that would protect such people from any kind of discrimination or any kind of persecution from the employer, for example, or for other people that may be damaged by the information that is provided by the whistleblower. For our audience to understand, the whistleblower is actually the person that has some kind of work, economic or academic relationship with the person or with the activity he is reporting, and while taking into account Ukrainian legislation, this means that it has to be in some way connected to the corruption itself, because there are different approaches to this matter, and in some countries whistleblower does not necessarily mean corruption whistleblowing.
Right. It also concerns different spheres.
It may be right broader. And actually one of the amendments that was introduced to the draft law 1010 on it's 1010, yeah. 1010. During the committee on corruption prevention, on the anti-corruption policy in the parliament, actually related to this issue that the definition of the term may be broader, including not only corruption but human rights violation, ecology protection, health security and stuff like that.
So this leaves the space on further improvement of the legislation, so meaning that whistleblower might also get a broader definition in Ukraine than just corruption.
I think this is an evolutionary process that for us it would be an enormous step forward to actually implement the measures that have been adopted by the parliament right now, and if they work in the right direction, and if they really provide security and defense for the whistleblowers themselves, then we would have the next step as providing broader definition of this term itself.
Well, as Deputy Head of the Committee on Anti-Corruption Policy, Galina Yelchenko said, this new law is aimed at building a culture of responsible citizens who are ready to report corruption. Well, so she approaches such a thing as responsibility of Ukrainians. You have already described who is whistleblower in terms of Ukrainian legislation, but could you please tell us what is the remuneration for helping the law enforcement to uncover the corruption offenses?
This is one of the instruments and one of the benefits that is provided by the new legislation. Basically, in order to ensure that the person who is reporting corruption is not only doing it because he wants to be a good citizen, but he might actually get some financial benefits from it. The law introduces a financial reward that might be introduced to the whistleblower himself, which is 10% of the amount of the damages that has been done to the state. This means that, for example, if you're reporting corruption on more than 10 million hryvnias, you could get 10% of that, which would be 1 million. But of course there are financial limitations to that. In order to be considered a whistleblower of corruption, the amount of damages has to be at least 10 million hryvnias, because if it's under that, the rights of whistleblower would not actually apply to you. And the amount of the sum, the maximum, I think, is around 12.5 million hryvnias itself, so that it isn't too excessive for Ukrainian budget to actually pay this amount of money to every whistleblower. There is another remark to this matter. The thing is that the person would get financial reward only when the court decision is being taken into place. So this is not done right after this message has been brought to the law enforcement agencies.
But after the
you have to go through the whole process in order to ensure that this would not be just a waste of time and money for the state.
Yeah, you're right. The maximum remuneration would amount in 3,000 minimum wages, which is, yes, as you
And
said,
this year is 12
about 12 million hryvnias. But why the threshold is 10 million hryvnias? About the corruption cases we're talking about. Why this new law concerns only large-scale corruption and not any lower-profile cases?
Well, first of all, in order to ensure that NACP has enough resources to fight corruption regarding its functionality, then NACP is a national agency in corruption prevention. Because if it gets a lot of messages regarding everything that is going on in the 45 million country, I think it would be extremely overloaded. And the problem is that one of the biggest threats to our economy right now is grant corruption itself. And I think that 10 million hryvnias, if you count it actually in dollars, for example, this would be less than $500,000, which is, practically speaking, not a great big sum considered some of the grant corruption cases that exist in Ukrainian state itself.
So they want to eradicate the biggest, the corruption on a highest scale first.
Absolutely,
and
I think one of the main reasons is because it has the biggest amount of damages to Ukrainian economy. Because
for sure.
World Bank and the International Monetary Fund approximately actually consider it to be about that the grant corruption causes at least 4 to 5% of Ukrainian GDP being taken away each year. This is grant corruption cases. Can you imagine if these billions of dollars would go not into the pockets of the corrupt officials, but into Ukrainian budget? This would be a great step forward. Absolutely.
Right. What if a few people report on the same case?
They would have so-called solidary reward, which basically means that if they provided the same amount of information, they would have to split this reward. And once again, for everyone to understand, this has to be a new information that actually helped the investigation. Because if, for example, everybody knows something and you're reporting is as a whistleblower, if in hope to get some financial reward, this would not work that way. You would have to provide a substantial information that would help the case, that would help the investigator to prove it in the court. And only afterwards, if it did help, actually, you would get this financial reward. But I think the main point here is what you said at the very beginning, that every citizen of the country has to understand that it's his or her responsibility to fight corruption as well, because this is one of the biggest threats to our state and our economy right now. And it is our common responsibility to work on this total zero tolerance culture against corruption itself.
It's good that you're referring to this sense of responsibility concerning Ukrainian citizens, because, of course, as any other draft law, there was criticism about this one. And now I want to mention Serhiy Vlasenko, MP from the Fatherland bloc. He fears that the experience of USSR may be repeated, when neighbors could rat someone out because of some insults and provided information out of their imagination. So are there any reasons this law could potentially evolve into this?
I wouldn't share the same concerns because, first of all, the main thing here to understand is that without the proper work of the law enforcement agencies, this law would not be instated and implemented the way it was supposed to be. So if the law enforcement agencies fail to do their job properly, it doesn't matter actually whether we have this law or another law on whistleblower protection, because this is their main focus. Another thing is that we're not introducing any new measures to the criminal procedural code. We're not introducing any new measures that would take away any civil rights from the citizens themselves. There is still due process, there is still criminal procedure, so I wouldn't compare anything to the year 1937 like Serhiy Vlasenko said, because this is absolutely a totally different situation, and this basically means that we are not taking away the rights of others, we're actually making sure that the people who want to help their country are being protected. And basically this does not take away any kind of civil rights from the people who would be prosecuted in this process, because there is still criminal procedural code and there is still the due process that existed beforehand. So if you want to be protecting yourself, calling yourself a lawyer and providing evidence that you did not do something, you are very welcome to do that. But there is still presumption of innocence, and this means that you may be silent at all times, and the law enforcement agency has to prove that this crime has been done itself. Your job is only to basically say, if you do not willing to say anything, you may say that I'm innocent and that's it.
Two more issues that are being debated over around MPs. First, anonymity, and second, the lack of requirements for whistleblowers to reveal sources of their reports on corruption. What are your thoughts on these two?
Well, unanimity is a good instrument for the whistleblowers themselves, because if they are afraid to do that, they may use this kind of instrument in order to make sure that they would not be discriminated or had any problems with their employer or any kind of other person that
just not to be in risk.
Absolutely. But if they want to get a special protection, if they want to get any kind of additional security from the state, they would have to reveal their person anyway. This means that I wouldn't say that anonymity would work 100%, because absolutely, if you want to go through this case, if you want to get additional security instruments, you would have to reveal the name of the person, at least to the law enforcement agencies themselves. And then as to the second issue you mentioned, is the fact is that the whistleblower has to provide a substantial information. And the work of the law enforcement agency or the law enforcement body to check whether it's true or not, and to provide judicial investigation. And the thing is that there is no point of actually revealing the sources, because if this information is false, then first of all, it would not go any further. And second of all, if this was done on purpose by the whistleblower, he may face responsibility himself, because this would mean that a lot of financial and human resources have been spent by the state, which has not been done properly. And this is all because of the false information that has been provided by the whistleblower himself.
Right. The responsibility for false reporting still remains, because we have it enshrined in the criminal code. So does this new law go in line with the European Union directive on the protection of whistleblowers?
More or less. The thing is that international experience in protecting whistleblowers is quite different. For example, in United States of America, a whistleblower can get from 15 to 25% of the sum that has been reported if this information once again has been considered substantial enough. In South Korea or in Japan, this information is being used in order to provide proper investigation of the case, but there is no financial reward. And EU directive so far, the best practice that it provides is the broad definition of the whistleblower himself or herself. So this basically means that there is still room for improvement, like, for example, to have a special electronic office for the whistleblower where he would check the criminal case, where he would make sure that the information he provided is being investigated and it's not just a waste of time. And of course that this may not refer not only to corruption, but to human rights violations, to food security, to ecology, and I think this is the next step that we're going to do. But at least for now, let's hope that this instrument would work in this particular issue, because without the proper work of the National Agency on Corruption Prevention, which is being relaunched right now as well, you know that we have 60 days for the appointment of the new head of the NAPC, and without the proper work of the law enforcement agencies like NABU, like the National Police of Ukraine, this may lead to nothing as well. So once again, it all comes back to the rule of law in our country and the existence of proper, impartial and independent law enforcement system and judicial system itself.
Right, judicial reform is underway. We can see that, but the very last question, I know that you already referred to it during the interview, but still, apart from the anonymity, how can the whistleblower, how can he or she feel protected? I mean, what are the other mechanisms that these corruption or some other personal links would not pose a risk to the potential whistleblower and to his life or maybe his career?
Well, first of all, whistleblower gets his or her right after the reporting. So he does not need to be put in some specific register, or it has to be checked and then only get back to. That means that you are the whistleblower from the very moment you took the information you have and provided it and reported it to either internal channels or external, which means that you provided it either to media or some external NGOs or to an ACP itself. And taking this into account, after you have this status of whistleblower, you are obliged and you are basically entitled to free legal aid, to having any kind of refund for the legal services you may take into place by yourself. Then you can have a psychological help itself that could be provided by the state as well. And more than that, you would get the same protection that the witnesses in the criminal cases would get under their state protection services. So if you want to, you can apply to the government in order to ensure that you are being protected, and not only specifically you, but also the members of your families as well. And another thing is that from this moment, the employer does not have the right to impose any sanctions on you, which means not only being fired, but, for example, like taking away your vacations, or making sure that you do not comply with any criteria during providing or doing your work, and any other additional instruments that may go through the job process. And this means that if you're saying that at work after you reported something that led to corruption investigation and the employer wants to somehow punish you, you have absolutely 100% right to go to any national agency on corruption prevention and say that my employer is not fulfilling its obligations. He is basically violating my rights, and this can be taken to court itself. And more than that, employer has to prove that the sanctions that have been imposed on the whistleblower were imposed on him because of his bad performance and not because of his whistleblowing beforehand.
Well, just worth mentioning that this new law comes into force on January 1st, 2020, and let's hope that this whistleblower procedure will have a broader area of its impact and implementation, not only the judiciary system, but also maybe human rights violations or food safety, etc. So far, I thank you for these comments, and thank you for being a guest today in the studio. That was Maksym Kostetskyi, lawyer, legal expert. Thank you for watching Head to Head, and stay tuned for more with UATV.